House Bill 2369 pending. The chair would now lay out House Bill 2998 and recognize Representative Rodriguez to explain that bill.
Great. Thank you again, Mr. Chairman. My last one here this afternoon. Members of the committee, again, this is House Bill 2998. The Texas chapter of the Alzheimer's Association came to my office with this bill, which seeks to add Texas to the very long list of states that currently recognize a codified set of procedures for determining interstate jurisdiction in cases of adult guardianship or conservatorship. Currently, there are approximately 350,000 individuals in Texas who suffer from Alzheimer's disease. It is imperative for us to make sure that guardianship proceedings for these individuals focuses on their desires and wishes of family and caregivers. In general, a guardian or conservator may be appointed by the court in a state where the individual is domiciled or physically present. Determining the correct court can be confusing, as multiple states could have jurisdiction. To be clear, we're not attempting to change any laws regarding who in particular may be appointed as a guardian, only the procedures by which different state courts can communicate with each other in order to determine the most appropriate venue for doing so. Jurisdictional conflicts are common. Older Americans are especially at risk if they maintain homes in multiple states or if their children live elsewhere. Under these procedures, the adult's home state has primary jurisdiction, followed by a state where the adult has a significant connection. Occasionally, another state may have jurisdiction if it is the more appropriate forum. Procedures for emergency situations and other special cases are also addressed. This bill also facilitates the transfer of guardianships. Relitigating a guardianship's terms can be costly and time-consuming. This would eliminate unnecessary duplication by providing a simple process to transfer uncontroversial guardianships between states. Due process is preserved, as all interested parties must receive notice and an opportunity to object. This bill also enhances interstate recognition and enforcement of guardianship orders by registering guardianship orders in external states. This simple procedure enables a guardian to act in multiple states if necessary, for example, to sell a protected person's real estate. I'm sure you'd all agree it's our responsibility to make sure that proceedings around the safety of our most vulnerable family members are as cost-efficient and hassle-free as we can make them, and we can do this by adopting this legislation, becoming part of 40 other states and jurisdictions that recognize the same procedures. Members, lastly, I'll note this bill has got a long list of supporters, including the Alzheimer's Association, the AARP, the National College of Probate Judges, and I'll note for my Republican friends on the dais, Governor Abbott was in favor of it on the campaign trail, so I may have just lost Representative Raymond on that one, but he expressed some I think, desire to work with associations like the Alzheimer's Association and AARP to make sure that these are courts can communicate with each other and making sure that they're impacting families in a positive direction. So thank you, members. I am happy to answer questions. I've asked the witnesses, I know there's several listed, to be as concise, thorough but concise, and they're also here as resources if you have more specific questions.
Any other questions for Mr. Rodriguez? If not, we'll go ahead and call the witnesses that we have. We have, first of all, Christina Holt with the Alzheimer's Association and herself.
Thank you, Chairman and members of the committee. My name is Christina Holtz. I'm from the Alzheimer's Association. I represent our 6 Texas chapters as our state affairs lead. In Texas, as Representative Rodriguez said, there's a large number of individuals with Alzheimer's disease, and in just the next 10 years, that number is expected to reach 490,000. There's over 5 million Americans nationwide, seniors with Alzheimer's disease. So what I'll also add is that 15% of the caregivers for these individuals live in a long-distance situation. Due to the impact of dementia on a person's ability to make decisions and in the absence of advance directives, people with Alzheimer's often need the assistance of a guardian. The Alzheimer's Association is in support of House Bill 2998 because it would simplify the process for resolving jurisdictional guardianship issues, allowing cases to be resolved more quickly, predictably, thereby eliminating the emotional and financial burden from duplicative filing. And that is all I have. Thank you.
Thank you for being here. Any questions, members? Anybody has any questions? Okay, thank you very much for coming today. Our next witness is Terry Hammond on behalf of herself in favor of the bill, or himself, I'm sorry, on behalf of the bill.
Thank you, Mr. Chair, and to the committee. My name is Terry Hammond. I'm in support of House Bill 2998. I view House Bill 2998 as being very much in the spirit of the reform that we've seen in House Bill 39 that Representative Smith, you have sponsored and that the committee has already considered. Basically, House Bill 2998 increases the protections for people who come under guardianship in the state of Texas. I have been on the National Guardianship Association Board of Directors for about 20 years, was executive director for 4 years, and on the Texas Guardianship Association Board of Directors for 3 years. I've worked on a lot of public relations problems in guardianship. The worst issues we've had that have been publicly reported have been in these interstate guardianship conflicts where families are, someone's taken from one state to another state. There's presence jurisdiction like we have in Texas. A judge can exercise control of that person's life and then decide what happens to that person, whether they are from, you know, even if they've never had any real contacts with the state of Texas. You're getting some paperwork passed out to you here. This includes a great deal of support from other organizations around the state and around the country. I want to say that my practice is primarily my law practice, and I'm in El Paso, so we probably deal with more cross-border issues than a lot of other jurisdictions around the state. I represent families, and I deal with families on these issues, and in fact, I just got an email from my office where we handled a case where a woman lived in Colorado just about all of her life, was brought to El Paso. Family in Colorado tried to get a restraining order and all to keep her there. She was taken out of the state before the court could intervene. Guardianship was filed in Texas. The judge said, she's from El Paso now. I'm going to exercise jurisdiction over her. She's back in Colorado now. We don't have uniform laws, so the judges aren't looking at the same things. What I just got from the office was that there's been $128,350 removed from her account by a power of attorney in Colorado. So does the Texas court have jurisdiction over an agent under power of attorney in Colorado? Probably not. So the big question is, who's going to take charge of this situation and resolve it for this elderly person who has been exploited? I tried to get a number of family members to come and testify. The problem is that they are all in other states, and they have been subject to proceedings here in Texas. You do have in your materials, though, a letter from a gentleman named Eduardo Chavez, who is the son of a now deceased, the director of the El Paso Symphony Orchestra. His mother, after his father's death, was taken by his brother out of El Paso to Idaho, never to return to El Paso. If you look at Eduardo Chavez's testimony or his letter, you'll see the impact this can have on families who have to deal with these issues when we don't have uniform laws. I have worked on a number of high-profile cases. One I was involved in was Lillian Glasser, woman who lived in New Jersey, had a home in Florida. We have a lot of snowbirds coming, temporarily to different states. She was brought to Texas by a niece for a visit, filed for guardianship in Texas, jurisdictional battle between New Jersey and Texas, about $1.5 million to $3 million in attorney's fees over this interstate guardianship battle. We have also, I think that Mr. Fields is going to talk about Lois Juanita Parker. Finally, I worked on a case where a woman was brought from out of state to Texas, and the judge says the legislature allows me to exercise jurisdiction over her. I'm going to do that, and she remained in Texas for 6 years for the remainder of her life, never got back home. So we ask that the committee pass and approve this House bill. I will say that 10 years ago, those of you who were here back then, we brought a big legislative reform issue before the legislature on adult protective services ended up being Senate Bill 6. Totally reformed the way that we were doing guardianship in Texas. There were some judges at that time who did not agree that it needed to be done. It needed to be done. Our system is better now. And if we pass this bill, our system will improve even so more. Thank you very much. I appreciate it.
Thank you for being here. Any questions for Mr. Hammond? Thank you very much, Mr.
Thank you, sir.
Hammond. We have Xavier Benalis. We're here with on behalf of himself and the Texas Guardianship Association in favor of the bill.
Good afternoon, Mr. Chairman, members of the committee. My name is Javier Bañales. I am the President of the Board of Directors of the Texas Guardianship Association. I'm also the Chief Executive Officer of a non-for-profit agency in El Paso. One of the services that we provide is guardianship services. And I'm here to speak in favor of the bill 2998. We believe in, with the Texas Guardianship Association, we have approximately 2,500 to 3,000 persons under guardianship through the various family guardians as well as other guardians who are certified through the state. And we believe that this legislation is sorely needed. As has been mentioned and as will be mentioned, also this addresses jurisdictional issues that arise when persons under guardianship travel across state lines, and issues arise regarding the various family dynamics or health issues and warrants court intervention. And of course, the issue, as Mr. Hammond has mentioned, the issue of jurisdiction often arises. There are property issues that arise also when a person proposed to be a guardian, a ward of the state has property in different states. And the issue, again, arises, the law clarifies a number of these points. Hospitalization issues is also an issue that arises, and having a uniform law throughout the states is something that is very sorely needed. Again, it defines the primary jurisdiction of the home states, and it will make it a lot easier to provide better coordinated services for persons who are under guardianship. So on behalf of the Texas Guardianship Association, we do encourage your support for House Bill 2998. Thank you.
Thank you for being here. Any questions for Mr. Benalis? Thank you very much. We have Helen B. Flores here on behalf of herself and the Alzheimer's Association.
Good afternoon, Chairman, members. Thank you for letting me speak here today. It's my first time, so I'm very excited for this process. My name is Helen Flores. I am for House Bill 2998. I'm a former caregiver of my father who suffered and has since passed from dementia. I'm also in the in-home senior care services as a professional, but I'm also a volunteer for the Alzheimer's Association. And without repeating my esteemed colleagues' verbiage, I did want to add that people come to Texas because it's less expensive to retire versus the East Coast and the West Coast. And so the impact, knowing that you were quoted by the year 2025, the amount of residents here with Alzheimer's or another form of dementia will be approximately 490,000 people. I only see that increasing. And also I wanted to tell you that of our surrounding states, Louisiana is the only one that has not passed this, and it's also going through the legislature. But of course, Arkansas, Colorado, New Mexico, and I hope, of course, Texas will pass this UAGAPSHA House Bill 2998. Any questions?
We appreciate you being here. Any questions, members, from Ms. Flores? Thank you very much.
Okay, thank you.
We have Virginia Funk here as well on behalf of herself and the Alzheimer's Association.
Good afternoon. Thank you, Mr. Chairman, and all committee members. I really do appreciate this opportunity. I am Jenny Funk, and I am here representing both the Alzheimer's Association, and I, too, am personally a caregiver for my mother with dementia. I am we are absolutely for House Bill 2998. Currently, Alzheimer's disease is the most expensive disease in America. And without a doubt, dementia and Alzheimer's disease affects a person's ability, all of their ability, to make safe and sound decisions and judgments for themselves. So that does often lead to guardianship. Not passing this bill, we do believe, will negatively impact caregivers with two things: their resources and their time. Two things that caregivers do not have any to spare. So I sincerely hope that you will absolutely listen to all of our fellow advocates and our passion towards this. We really thank you for this opportunity. Any questions?
Any questions, members?
Okay, thank you.
All right. Chair calls up, I don't know who's small. Okay, Stephen Fields, representing himself.
Thank you. My name is Steve Fields, and I'm a court administrator, staff attorney for Probate Court 2 in Fort Worth, Texas. And I'm in favor of this bill. This is the third session I've argued that Texas should consider passing this. Back in the first time it was offered, only 21 states had passed it, and now we're up to 40 states. And the reason I'm so in favor of it is it really improves current Texas law in two major ways. And I wanted to present those as questions. If somebody called me on the phone, because I get a lot of phone calls during the day asking legal questions, could I bring my 90-year-old incapacitated mother who's lived in Oklahoma her whole life to Texas and file a guardianship on her to prevent my brother from being appointed as her guardian in Oklahoma? Well, under Texas law, yes, you could. As long as she can be served in Texas, the court has jurisdiction to appoint a temporary or permanent guardian for her. And even if your brother gets appointed guardian in Oklahoma, as long as you're in Texas and you've got a guardianship, she stays in Texas. And that was the case of Lois Juanita Parker from 2008, and that was upheld on appeal in Texas Court of Appeals Amarillo in 2008. But under this bill, the answer would be no. Your mother would have to be a resident in Texas for at least 6 months before a Texas court would have jurisdiction to hear an application for permanent guardianship. But if your mother came to visit and she had an emergency that required a temporary guardianship, you could file for that in Texas, but Oklahoma would retain jurisdiction to hear a permanent guardianship because that's her home state. And I think that's a very important improvement in Texas law. The second one is a question, if I had a guardianship of my mother in Kentucky, but we want to move to Texas, can I apply to transfer my guardianship to Texas and be assured that the Texas court won't appoint somebody else as guardian? Well, the answer under Texas law is no. In Texas, you apply to the court in the county you want to move to, you send notice to your mother in the Kentucky court, there's a hearing, Texas grants a transfer, they give full faith and credit to your mother's incapacity and rights and powers and duties of the guardian, but there's nothing that says they can't change the guardian. And that's exactly what happened in a case involving a resident of Kentucky that wanted to move to Alabama, and the court, there was another daughter involved, and she said, oh, my sister's been spending money, so they appointed a guardian ad litem. They said, you know, we'll take the guardianship, but we're going to appoint the guardian ad litem as guardian of the estate and the county attorney as guardian, and so they basically hijacked a guardianship. Under the bill you have before you, there would be a procedure where there's provisional orders signed in each state. They would have to accept the guardianship as is before they started modifying it. And I think that's a very important distinction as well. And so I would urge you to pass this bill. Thank you.
Members, any questions? All right, thank you very much. Chair calls Bob Leonard, representing himself, in favor of the bill.
Thank you, Madam Chairwoman, committee members, and Ms. Thompson, who I served with down here for over 10 years, I guess it was. She sat right in front of me on the house, but my lips are sealed.
Well, welcome back.
I was asked to look at the Uniform Adult Guardianship and Protective Procedure Jurisdiction Act, and I will say that whoever thought up the name probably should be shot, because I practice primarily family law. I do some guardianship and I do some probate work. Probably 25 to 30% of our practice is that, and the entire rest of it is family law. For years, I have been dealing with the Uniform Child Custody Jurisdiction and Enforcement Act in the family law realm. And I was asked to how those compare. I was asked how that works on a practical matter. So I pulled out Representative Rodriguez's bill and I read it, and I shouldn't have been shocked, but I was kind of surprised at how closely it tracked, not wording, but many of the same provisions of what we refer to as the UCCJEA. I probably have 3-4 cases a year, some years not that many, that involve interstate family law matters, having children in one state or the other. It tracks it in a lot of ways. It sets up original jurisdiction. I guess I'm the appointed nerd for this. It sets up original jurisdiction with the same 6-month rule, although the guardianship one does provide alternatives that are not available with children. Both of them set up emergency jurisdiction for circumstances where that's necessary. Both of them provide for exclusive and continuing jurisdiction once a court required jurisdiction of a ward. Both of them set up a process for how you transfer a case, and I slowed down when I said the word transfer because the language in the UCCJEA doesn't exactly use that language, but that's the way it's actually practiced. They refer to it modifying an order from another court, but it's the same thing, and from a practical viewpoint, it reads exactly the same way. Our law, our original statute, the UCCJA, little different, was passed 47 years ago in Texas, the same year I graduated out of high school. Don't do the math, please. 16 years ago, the UCCJEA was passed. The reason that it was passed was, to a big extent, several states had changed the language of the Uniform Act. And because of that, you had different court constructions across the country, and the UCCJEA, the successor one, the one 16 years ago, was primarily designed to eliminate some of these differences. So I think there's a warning there to be careful about changing language in uniform laws. There are several things that are significantly better in, I say significantly better in this, but I want to talk about one in particular. The bill provides something that we've done in family law for many years. It provides for courts to talk to each other across various states. I have, I don't know, 1, 2, 3 cases a year where the judges literally pick up the phone and call each other. I have never had a case where they weren't able to work anything else out. The Adult Guardianship Act actually is better than the one we have in the UCCJA in that it provides 9 standards for them to talk about. None of them's more important. In one case, numbers 2, 4, and 6 might be more important. In another case, numbers 1, 3, and 5 might be more important. But it does provide standards to talk about. I wish we had that in ours. There are several things that they've cleaned up that I hope they go back and add to the UCCJEA, but I'm just here to say that if it weren't for the UCCJEA, our process would be a lot more expensive. I'm very sensitive to the cost of guardianship, and I think if you have something like this where you don't have the conflict between states, there's no way that you're not going to save money for the parties, and more particularly for the wards and proposed wards that from whose estate most of the money frequently comes. Thank you.
Any questions, Representative Schofield?
I made a miss at the beginning, but I'm not sure he did the whole stating his name and if he's for the bill.
I'm for the bill. My name is Bob Leonard. I'm an attorney practicing in Fort Worth.
And your position on the bill?
I'm sorry?
And your position on the bill?
For the bill.
For the bill. Okay. I said it for you. Okay.
Thank you.
Thank you.
And I don't believe that you robbed the bank either.
All right. Chair calls Patrick Birchill, representing himself for the bill. And make sure you say it all over again, please.
Well, it rhymes with Churchill. That's what I put on my handouts when I ran for election. Birchill rhymes with Churchill. Madam Chairman and ladies and gentlemen, I'm the judge of probate court number 2 in Tarrant County. It is a statutory probate court, and I'm here representing myself today. Of course,
state your position on
I am for the bill, and I am representing myself.
Can you say your name again so we can catch it on the
Patrick W. Birchill.
Okay.
All right. Now, I echo what all the previous speakers have said about what I consider to be the merits of this bill and the merits of Guardianship. It's taken me a while to learn that one as well. But I want to focus right now on mediation in particular. If we assume, and I'll let you pretend you're Representative Smithy, and Ms. Clunder and Ms. Stingley have an elderly mother, and they live in different states. And Ms. Clunder has taken her mother from Ms. Stingley. She's gone up to Oklahoma or Louisiana and taken her mother allegedly for a visit, and then she refuses to take her back. So each of them file guardianship actions, let's say in Texas and Louisiana. Under the current Texas law, here are the 4 things a judge, if I were one of the judges, would consider. Number 1, interest of justice. Well, Ms. Clunder, don't you think it's in the interest of justice for you to have your mother? Ms. Stingley, what do you say to that? The next one is the best interest of the proposed ward. Well, Ms. Stingley says, of course, mother's better interest or best interest are living with me. I live in her hometown. She never did like that part of Texas anyway. Then Ms. Clunder says, well, we've got better hospitals, we've got more doctors, we're an urban area. It's better for my mother to be in my hometown. Then we go to the convenience of parties. Oh, well, both of you say it's more convenient for me to litigate in Louisiana or in Texas than it is to drag all my witnesses and everybody to another state. And then lastly, we have preference of the ward. And I do not mean to in any way demean the preference of the ward. It is extremely important. However, Mama, when she's with Ms. Clunder, wants to live with Ms. Clunder. And when she sees Ms. Stingley on a visit, she wants to go live with Ms. Stingley. Or even worse, if Mama were in the 3rd stage of Alzheimer's, she may not be able to even audibly give her attorney or anyone else a preference. So what we've got here is a perfect setup for smart, enterprising attorneys, because they can make arguments, cogent arguments for each of you. It, in fact, encourages litigation because everybody can want the best interest. Everybody can want convenience of the parties. Now, UGAPSHA is different. As former Representative Leonard mentioned, there are 9 standards. So the judge has to look at 9 things, and they're concrete issues, so that here is what they would look at. The proposed wards express preference. Number 2, whether abuse, neglect, or exploitation of the proposed ward has occurred or is likely to occur, and which state could best protect the proposed ward from the abuse, neglect, or exploitation. Number 3, length of time proposed ward was present in or a legal resident of this or another state. Number 4, distance of proposed ward from the court in each state.
I'm sorry, I'm not the lawyer, so I'm trying to absorb.
All right, we'll move this along by saying there are 9.
You're for this bill.
I am.
And the things that you are describing right now, this bill would help those situations.
It would give a mediator 9 things to look at. Okay. And it would allow the mediator to say, Ms. Clunder, there are 5 of these that don't look so good for you. Ms. Stingley, there are 4 of them that look pretty good for you. You ladies we need to sit down and mediate this. Mediation saves money and it repairs family relationships.
Okay.
Any
perfect.
questions?
Any questions for me? All right, thank you so much. Okay, let me set all this back. All right, chair calls Bruce Bauer, representing himself and Alternatives to Guardianship, Inc., in favor of the bill. And can you say all that again, please, in your words?
My name is Bruce Bauer. I'm an attorney here in Austin. I'm chair of Alternatives to Guardianship Incorporated.
Yeah, who are you representing?
Sure. I'm representing Alternatives to Guardianship Incorporated and myself, and I'm here testifying in favor of House Bill 2998. And again, I won't echo everything that everybody else has said, word for word. I would say that this bill would allow for communication and cooperation among jurisdictions in a matter that deals with people who are alleged to be incapacitated. And I think we need to keep that in mind, that this is another guardianship bill, just like House Bill 39 by Chairman Smithy, that focuses on what is best for the most vulnerable among our society, people who are alleged to be incapacitated. It addresses emergency situations. It provides for an appropriate response to unjustifiable conduct in regard to transferring or not transferring guardianships, and it will allow for Texas courts to arrive at the best response to a person with incapacity most quickly and with the least necessary drain on resources. Please pass this bill.
Thank you. Are there any questions on this? Thank you very much. Okay, Chair calls Mary Frances Davis, representing herself, in favor of the bill.
Thank you, Madam Chairman, members of the committee. My name is Mary Frances Davis, and I have early onset Alzheimer's.
Can you say who you
and I am in favor of the bill.
And you are representing yourself?
Myself.
Okay. Thank you.
My name is Mary Frances Davis, and I have early onset Alzheimer's disease. When I was first diagnosed, one of the most important things for me was to see a lawyer and get those documents necessary so that when such time comes as I cannot make my own decisions, that my husband or my children would have the legal documentation necessary to proceed without any struggle. I'm blessed in that my husband, my daughters, and I all live in the state of Texas, so it doesn't impact us directly. However, I was surprised and disappointed that the state of Texas hasn't endorsed this uniformity. I was shocked that we weren't among the 40 states that have already endorsed. In choosing to adopt this act, you will enable Texas courts to work with courts in other states to facilitate guardianship documents in those cases when all affected family members don't live in Texas. Currently, our state judges and courts are constrained from this. I cannot imagine the burden this must create for multi-state families who are dealing with the significant emotional and financial challenges of caring for a loved one who has become unable to make health and other life decisions for themselves. I certainly would not want my children to face those daunting legal and financial challenges, in addition to living with a heartache that Alzheimer's will debilitate me. I'm here today to urge you to move this bill forward for the sake of all Texas families dealing with Alzheimer's and other dementia and debilitating diseases. Thank you very much for your time.
Are there any questions? Thank you so much for coming.
You're very welcome.
The chair calls Craig Hopper, representing himself against the bill.
Thank you, Madam Chair. My name is Craig Hopper, and I am currently the chair of the Legislative Affairs Committee for the Real Estate Probate and Trust Law sections of state and trust committees
Who are you
for the state
representing?
bar.
Are you representing them?
I'm representing myself, though, today.
Just yourself?
Yes.
Okay.
The reason why I was saying all that is because I wanted to bring up some background of...
Okay, can you say your position on the bill?
I'm against the bill,
okay.
Madam Chair. But I'm not against what almost everybody has said here today, with the sense that we are here in Texas to help represent and take care of those folks who need representation because they're incapacitated. And that's not necessarily what this bill is about. Texas has always been the leader among all the states in our jurisprudence system regarding guardianships. And it's something we should all be very proud of, and y'all should all be proud of for creating. And when interstate guardianship transfers first became in the news about 10 or 12 years ago, the guardianship code, the portion of the probate code, was modified to allow for a way to help transfer guardianships from one state to another. And so that's been in our jurisprudence for some time. It was only after that that other states realized, oh, we don't have anything like this, and the Uniform Act then came down, and certain states started adopting that. Now, all of these states want to do the same thing, which is to help out incapacitated folks. The issue is whether or not we currently have a framework and a system that takes care of it, or whether or not it needs to be revised. We looked at that at Reptil, along with the statutory probate judges, about 6 years ago. And then 4 years ago, there was a legislative change to the statutes that took what we all felt was good about the Uniform Act and implemented that into the current Texas jurisprudence. So we've looked at this, and we've modified it. And now it's 4 years later, and the exact same statute is being offered up. It does not help out the system of Texas jurisprudence. It doesn't add anything, but more importantly is that because it's a uniform act, it doesn't fit well within our system. If we just dump that into the estates code right now, it's going to cause confusion in other sections in the estates code that deal with guardianship. So even though I think we're all wanting to do the same thing, which is to make sure that incapacitated people aren't abused when moving from one state to another, this needs more work to try to determine how it can best fit within our system of jurisprudence. Now, I think it's unnecessary, but I can understand everybody's heartfelt comments here, and I agree with them that what they're wanting to do is a good thing. But my position would be that that is already happening, and we don't need to change anything without further study. And I'll be glad to answer any questions that I can.
Any questions, members? Okay, thank you. All right, Chair calls Steve King, representing himself against the bill.
Madam Chair, members of the committee, I am Steve King. Excuse me, I am Judge of Probate Court Number 1, Tarrant County, Texas. I am the former president of the National College of Probate Judges. I'm a past presiding judge of the statutory probate courts of the state of Texas. I was a member of the work group that worked on...
Okay, Mr. King, before you get started, are you here to represent yourself?
I am representing myself.
And your position?
I am against the bill.
Okay, thank you.
I was part of the work group in 2009 that studied the Uniform Act. There were 5 lawyers, 5 judges. We studied everything in the act, the very same act that is before you today. We took what we thought was best for Texas from it. We implemented that. That is a chapter in the Estates Code. It has long been the pattern in Texas that uniform acts get handed to us, and the state bar and concerned parties study these and take what is best from those and sometimes improve upon them. And I want to echo what Mr. Hopper said. I have the same concerns that every witness before you today has expressed. I deal with guardianships on a daily basis, and I have for 20 years. I did for 17 years before that in private practice. We want what is best for the proposed board. We are very concerned when someone is taken from one state to another state. The Uniform Act imposes constraints upon the judge, which the current Texas law does not. It creates presumptions, which I think front load the decision of the judge and hinder the judge from making the best decisions. I know your time is very valuable. I'll refer to my written comments.
Okay, thank you. Y'all have any questions? And as Chairman Smithy would always say, have you had a chance to visit with the author of the bill to express?
I've had a chance to visit with the commissioners of the Uniform Act.
Representative Sheep.
Thank you, Madam Chair. Just, Judge, really quickly, is this the first time that this is being considered in the legislature?
No, sir. This is the 3rd time this has been considered in the legislature.
Okay, and
this very same act.
The very same act?
Yes, sir.
So, how far has it gotten in the process?
Well, it was studied by the state bar and a work group of judges, and we proposed a substitute, which is currently Texas law. It is a chapter of the Texas Estates Code, and it addresses all of the considerations, but does not have the presumption, doesn't have a list of 9 things. It leaves it more to the judge to use common sense instead of having to have an extensive checklist which must be addressed.
Okay, thanks, sir.
Thank you.
Okay, thank you. Chair calls Thomas Ruffner, the Travis County Probate Court, against the bill.
Good afternoon. This is my first time, so I'm a little bit nervous, and my name is Thomas Ruffner. I am the Guardianship investigator at the Travis County Court, Probate Court number 1.
That's who you're representing?
But I'm here representing myself, and I am here against the bill. It's my first time registering.
No,
so
it's okay. Listen, it's my first time to look at a lot of this stuff too, so I get it.
I don't want to take up too much time and be redundant with what Craig Hopper previously said and Judge King had just said. I too agree with the same sentiments as what the people for the bill, what they're here for. As the court investigator, my main job, I tell people when they call every day, is that my main concern is for the wards, not in Travis County, but wards in the state. And I'm not as concerned about the guardians or the court. Its number one goal is taking care of the ward. But I just wanted to kind of go off of what Mr. Hopper had said about how the statutes currently in place already address some of these issues. Specifically, there are 3 sections in the House Bill 2998, which are already in existence in the current estates code. Specifically, the section dealing with establishing a guardianship of the estate for a non-resident ward, also a court declining jurisdiction by reason of conduct, and the statute where a guardianship proceeding has been filed in two separate states, allowing the court here to take a step back and allow the other court to proceed if that's a more appropriate forum. I also want to note, and I'm not quite sure why, but the bill in the transfer statutes, both transferring a guardianship in and out, eliminates the best interest of the ward standard. And for cases being transferred from Texas to out of state, it's replaced by plans for care and services for the adult ward in the other state, whether they are reasonable and sufficient. So I think that given there seems to be a slight contradiction with the bill that's being set forward with the underlying sentiment. And with that, I thank you for your time.
Any questions, members? There's none. Thank you very much. Laura Upchurch against the bill.
Hi, I'm Laura Upchurch. I'm appearing here today for myself, and I am against the bill. Having said that, I do want to recognize that there are parts of the bill that do apparently need to be considered for inclusion in the Texas guardianship system. I chaired the Guardianship Legislative Committee for the Real Estate, Probate, and Trust Law section of the State Bar. I'm also a part of the WINGS initiative, which is the guardianship stakeholders group in Texas that was initiated about a year ago under the auspices of the Office of Court Administration. I say that just to let you know that I actually do look at these bills. I look at them from the standpoint of, is what's in this bill necessary within our current system? And frankly, I agree with Mr. Hopper and with Judge King. We already have the provisions from the Uniform Act that will benefit Texas jurisprudence. My bigger concern with this bill, though, House Bill 2998, is that it includes provisions that will conflict with our current system. As a, for instance, Section 1254.052 of the proposed bill says that exclusive jurisdiction for the court in a state to appoint a guardian of the person or guardian of the estate would be established under this act. And yet that conflicts with Chapter 1022 of the current guardianship code under the Texas Estates Code. They don't jive. So if you adopt the uniform bill in its entirety, you've just set up a juxtaposition for courts of, wait a minute, what applies in this case? Likewise, Section 1254.054 of House Bill 2998 would allow a guardian of the person to be appointed in an emergency for a term not to exceed 90 days. This conflicts with the temporary guardian provisions of Chapter 1251 of the current Estates Code. So what you're doing, if you enact this bill as it stands, is setting up confusion within the Texas Estates Code. And frankly, I don't think that can be worked out at this stage in the legislative process this year. I think that certainly the various persons who've gotten up here today and spoken in favor of the bill have brought up good points. I think they're points that need to be considered in a work group and allow the parts of the bill that do make sense for Texas to be able to be considered. But to adopt this bill wholesale as it exists today would wreak havoc with our current guardianship code, and I would ask that you not adopt the bill. Thank you.
Any questions, members? Okay, thank you, Ms. Upchurch, for being here. We have Judge Guy Herman on behalf of himself testifying against the bill.
Good afternoon, Chairman Smithy. I'm Guy Herman, probate judge here in Travis County. I'm here individually and I'm opposed to this bill for a number of reasons. We don't need the bill. We already have a law that has been in effect for a long time, even longer than some of our speakers realize. We got a recognition from the National College of Probate Judges where we were the first state to adopt a transfer provision where someone in Washington could transfer their case into Texas without a new hearing. Just by transferring the case down, we would have, I won't say not a new proof of hearing. We would just accept the transfer, make sure they had a bond and everything was going on. Now, the idea that any judge in this state would not appoint the person who was transferred their guardianship in, would not appoint that guardian, is ludicrous to me. If a judge did something different than that, I would be mortified that it would happen with a judge, because if a family brings someone down here, you do it. Now, we did hear a story about Alabama and Louisiana or Kentucky or something when somebody was stealing money and then the court decided neither one of those people that were in a dispute should be the guardian. That was probably a proper decision. Because one person is saying the other one's stealing money, the court must have decided there was a theft. Now, this business about the Glasser case, which was sometime in San Antonio, it wasn't a jurisdictional dispute. The woman was here. She was found in the streets. The guardianship was created. There was no guardianship in New Jersey. The San Antonio judge called up there. She finally had to appoint a guardian ad litem to go file a case up there because one side in the dispute in Texas did not want a guardianship and wouldn't dare file one up in New Jersey. Ultimately, it was transferred to New Jersey, and she was found to be incapacitated and put under a guardianship in her home state. We have transfer provisions. We have provisions to contact. It's been going on for 8, 9 years. You can call the other judge in another state and say, I'm going to transfer this case over there to you. We've been doing that. I've had conversations with judges in other states. I don't understand why we need that. And Laura brought up all these different conflicts. You all told the lawyers and the judges some 25 years ago we had 6 or 7 kinds of guardianship, to bring it down to fewer types of guardianships. And this is going to create some new type of a guardianship that lasts 90 days. What happens if the person who's under that special guardianship needs to be here longer than 90 days? What do? Doesn't say you could have another one. Where's your emergency guardianship? There's no emergency in those circumstances. We have a temporary guardianship for that situation. There is a number of redundancies in this statute that conflict with current Texas law, and the idea that this is going to cost less by putting that in, that is incorrect. There are provisions in the Uniform Act, notice provisions, which will cost and drive up the cost. This business of 9 different considerations, the 4 broad considerations that we have in Texas law, you can consider all of those 9 within those 4, plus you can add additional ones if something comes up. And what you do when you set up 9 considerations, you're going to ask a lawyer to put evidence on every single one, which is going to drive the cost up. You give a lawyer an idea, he will then put evidence on for you. Now, the best interest, Tom mentioned that it's no longer in there. That has been a major part of the code for a long time. The other thing I'm really troubled by, the last thing I want to say is international application of chapter. A court of this state may treat a foreign country as if it were a state for the purposes of applying this subchapter in the other sub. What does that mean? Are we going to, somebody comes from another country here, that they have more significant situations there, but they've been in Russia and they need a guardianship over here. We got to ship them back to Russia. We got to ship them back to Syria. We got to ship them back to Iraq. What does this mean when you say we're going to treat that as a state and somebody there could get the person back over there? We got rid of the best interest. And that is dangerous business when you start talking about this international law. I'm opposed.
Any questions for the judge? Thank you, Judge. We have Sherry Johnston once again, who is testifying against the bill.
My name is Sherry Johnston. I'm going to testify against the bill for the simple reason, if I became incapacitated, I never heard anybody speak about just the power of attorney. I mean, everybody assumes, bam, everything's guardianship. I see all this could probably been resolved with just a power of attorney. So I think these judges and all of us would need to get a different thinking mode, that, you know, when we're in different states and stuff, and mom likes her over there and she likes to be a power attorney, let her have her power attorney unless she's really doing something really crazy, because, you know, we have difference of opinion, and mom likes me more one day and likes you more one day, and, you know, she loves her kids, grandkids more than this one. And when we get our states involved into this, it just makes a big mess. So I think keeping things simple. And another thing too, for example, if one of my children was trying to put me into a guardianship, I would leave the state and I wouldn't pack my bags. And the thing I feel like, if, I don't know if this applies to this bill, but if I left Texas, I don't want you to come get me. Or if I'm in Kentucky and I'm fearful of a guardianship and I don't want to be there, I don't want you to come get me in Texas. So I need a safe haven, you know, and I just want to emphasize that all I've heard today is guardianship, guardianship, guardianship. Nothing about power of attorney or the least restrictive that the lady or grandma or grandpa would like. And I thank you for your time.
Okay, any questions for Ms. Johnson? Thank you, Ms. Johnson. We also have Debbie Valdez once again on behalf of herself and Grade against the bill.
Hi, my name is Debbie Valdez, and I'm with Guardianship Reform Advocates for the Disabled and Elderly. Interesting conversation we've had today here. You know, there has been some changes in probate since 2005 that, as I have observed, and in my time as an advocate for the elderly and disabled, I have seen that the actual person who guardianship was created and intended to protect and serve is really just being used for the benefit of others and their profits. I've been seeing that consistently across the board. If you study the estates code, if you practice the estates code, it's all about money. And the sad thing about it is we've created a system where we cannot even protect these individuals any longer. So this uniform code, I'm against the bill, because I think we have enough problems with guardianship in the state of Texas than have to incorporate dealing with other states before we fix what we've got going on here at home. People are dying. People are losing their properties. Families are losing their inheritance. They're losing their family members. And there is no such thing as preference of the ward in the 300 cases that we've gotten in through grade throughout the state of Texas. It doesn't exist. Just like a jury trial. Doesn't exist. It looks good in the estates code, so we're following the constitutional law, but it doesn't happen. And I can give you the numbers of cases that will prove that. So a lot of this is just another avenue to just make some money in a different jurisdiction, in a different state, to be able to take an elderly person, move them from one state to another state. As long as they've got property, there's an interest. If they don't have any property, there's not an interest. And court-initiated guardianships are going to be increasing the number of guardianships we have here in the state of Texas. Because anybody from any state in the state of Texas can call the court and say that a person needs a guardianship. And that person is forced into a guardianship. So, I think this bill is not a good bill. Thank you.
Okay, so I want to make plain you're testifying against the bill.
I am testifying against the bill.
We'll note that on the record. Any questions from Ms. Valdez?
Thank you.
Thank you for being here. Anyone else to testify for or against on House Bill 2998? Oh, I'm sorry. Come on up, ma'am.
I'm sorry, I didn't get a chance to register for this bill. I didn't
Okay.
realize.
Well, I'm going to need you to register before you testify, so we'll wait for you to register then. Okay, and once again, we'd remind you, if you wish to testify for or against any of these bills, please go ahead and sign in now. Go ahead, ma'am.
I apologize for the delay. My name is Christy Hood. Unlike my fellow people that I usually am in agreement with, I'm on this bill. If you're going to pass this bill, you should do so because these presumptions that they talk about limit the wide power and discretion of the judge. They protect the ward. I don't know if the other stuff is good, but I do know that anything that limits a judge's power to declare a person invalid, non-person, is good. And that's all I wanted to say.
Well, we appreciate your input on that. Any questions? Thank you very much. I'll ask again, anyone else here to testify for or against or on House Bill 2998? If there is no one, Mr. Rodriguez, you want to close?
I told y'all this was a simple bill. But Mr. Chairman and committee members, thank you for your attention. I know there was some split testimony on this, but I will just say that, I'm happy to visit with some of the folks who had issues with it to see if we can work those out. I don't think we've had a chance to visit, but, I think the idea here is to make sure that in cases where there is some, travel between states, that we have some uniform